Okay, hi everybody. Can you hear me? Somebody could just shoot a message if you hear me. Great. Can you also see my screen? Thank you, Shlomo. Perfect. Okay, thank you very much. Okay, so we are going to start. Thank you all for attending today. I hope you'll find this useful. Today's webinar is about ABA therapy minefield, navigating the risks for success. Now, this is a very interesting crowd. We have a great crowd today. What's interesting about it is we have all different kinds of people across the spectrum. We have starting from RBTs and BCBAs, all the way up to owners, COOs, and even lawyers. So I must say that most of you probably know a lot more than me about ABAs, but what I do want to share with you is a point of view of protection. You all have your point of view about ABAs, and I want to show you how it looks like. We are protection specialists, so I want to show how things look from our side of the table. And I'm going to go through a whole bunch of things, and I hope that either you'll learn something new, or if you don't learn anything new, then you will get some clarity on certain issues that you weren't sure about, and also that you have a new perspective, a new point of view of how to look at protection and keep that in mind as you operate or as you go through your career in the ABA therapy business. So your clinical model is about risk mitigation through behavior. Your business model should be too. And therefore, these are all things that we should consider. Now, what's interesting about ABAs, I'm going to try to go through these slides very quickly. I will send it to whoever wants afterwards, so you don't have to bother trying to read everything it says on the slide. We got a lot of slides and there's a lot of information, but I don't want to keep you too long. So I'll try to go through the important parts as quickly as possible. And I'll always be available for email questions or phone calls. And like I said, this is being recorded, and we can send you the slides. So ABAs are a little bit different. The other industry that we focus on a lot is real estate. Over here, you have people that are passionate about what they do, about helping children. After that comes the business side of it. And it's important because business does make the world go round. But the thing is that the focus is not so much on, the first focus is on the client, the business. The second focus is on making the business work financially, and compliance and protection is only, I would say, in third place in this totem pole. So it is important to understand that this business is loaded with risks. This is really a recipe for disaster. First of all, you're delivering clinical services, which is not just selling widgets. You're also billing the government and insurers, which is not an easy customer. You're also hiring licensed professionals. So all this combined makes this quite explosive, and certainly something that you have to be aware about on every turn. We're going to cover today 5 critical risks. The first one is liability. The second one is employment. The third is accounts receivable, which is the bulk of your business. The fourth is regulatory. And the last one, which we'll cover on, is exits. You may not be thinking about exits now, but every businessman knows that at the end of the day, there's an exit one way or another. And it's important to prepare for the exit because that will make a huge difference in how the exit goes for you. So the first thing we're going to talk about is structuring ABA companies, and we'll take it from a LLC point of view. What does an LLC do? LLC is your alter ego. But it's not only your alter ego, it's completely cut off from you. So if you have a business, if you go in as so let me see if we got a question here. No. Okay. If you go into business as yourself, that means your entire being is tied up into that business, which means if anybody sues you, they can take anything that belongs to you, which means your house, your car, whatever it is, your stocks, your investments, your bank account, it's all free game because they're suing you. What an LLC does is it says, okay, I'm me, but I have a business. That business, we put in a little box called an LLC. And that has nothing to do with me from a financial point of view. It's its own being. It's its own entity. And therefore, if somebody sues the LLC for any business that the LLC did, that's where it stops. It doesn't come to me. Now, there's two types of protection that you need when it comes to an LLC, two types of protection that it gives you. The first is if somebody sues your business, your assets are safe, your home, your car, and everything else. The second part of LLC protection is the other way around. It's called outside protection, which means if somebody sues you personally for a car accident or anything that happens on your property or anything that has to do with you personally, they cannot take your LLC away. But as we'll see in a minute, not all states have the same type of LLC protection, so that's something to keep in mind. The key takeaway here is that an LLC is a firewall. It separates that business from everything else around it. Now, not only, which we'll see in a minute, not only does it separate you from your business, it even separates your businesses from each other. And not only does it separate your businesses from each other, you can start pulling your business apart, picking off pieces in order to protect parts of the business if the other parts of the business get sued. And we'll talk about that now. Okay, so LLC protection, it doesn't protect you from everything. It protects you from business debts and contracts, employee actions, malpractice claims against one of your employees, and it separates your assets. What it doesn't do for you, if you have a personal guarantee, if you sign a bank loan with a personal guarantee, that means you have bypassed it. That means your personal life has become partner with the LLC, and the bank views you as personally liable. Payroll tax liabilities, the government says, we don't really care if you have an LLC, but for payroll tax, you will be personally liable. And another part is fraud or misconduct. So your LLC only protects you in the course of business. That's why the government created LLC, for you to do business and not have to take so much risk personally. But once you go beyond the scope of that LLC, and any fraud or misconduct obviously is beyond the scope of what your LLC can do, that means that you're the actor, not your LLC, and therefore you can get sued personally. And the last way you can get sued personally is by piercing the corporate veil. So what that means is the corporation is actually a veil. It protects, it lets you hide behind the LLC. But if you're going to do things that destroy that veil, so if you have sloppy books, or you're going to commingle your funds, or you actually sign on documents with your own name rather than the LLC's name, so the court will say, look, this is not an LLC, this is you hiding behind an LLC, and therefore you will become personally liable for anything that happens in the LLC. So it's very important to keep your LLCs in compliance and follow all the rules of LLCs. So an LLC, as we said, separates any problems you have in the business from you. But let's say something happens in your business, you're going to lose your business because everything in the LLC is fair game. That's where insurance comes into play. Insurance actually protects your business. So if your LLC has insurance and somebody sues you for $5 million and you have $10 million of accounts receivable, if your insurance pays $5 million, then your LLC will be protected. Another important part of insurance is not just that it protects you, but it also makes it easy for the lawyer to get the insurance money. So when a lawyer comes after you, a lot of times they'll just settle for whatever the insurance money has in order to move on. They don't want to be drawn into long court cases with you. If they can just get a quick settlement with insurance, it's usually, if you have a decent insurance policy, and depending what the claim is, it can often be worth their time, and therefore you will never have any liability and your LLC will come out scot-free. So we have this combined protection of insurance and LLCs, which can keep you personally protected, plus it can actually protect parts of your business. Now now I want to go to the next level of LLCs. So we said that not only does the LLC separate you from your LLC, we can actually pick apart parts of your LLC in order to protect the business. So what it would look like is that, let's say your business has assets. Let's take an example. We have a restaurant. Restaurants has ovens and all kinds of machinery. It's very valuable. It's probably the biggest part of their balance sheet. It also has real estate. What we want to do is somebody's going to come in and get food poisoning, and they're going to sue you, and you're going to lose. If it's all in one LLC, you're going to lose your entire business. You're going to lose your property. You're going to lose your equipment. You'll be out of business very quickly. What we want to do is separate the assets from the operational risk. So what you do is you set up an operating company. The operating company runs a restaurant. The asset company owns all the assets. So the operating company will then lease the assets from the asset company. It will lease the equipment. It will lease the premises. And therefore, if somebody sues the operating company is really a shell because it just collects revenue and distributes the revenue. It cannot take the assets because the assets are part of different LLC. And the asset company didn't do anything wrong. It was your operating company that the person is suing. So only whatever is inside that operating company is fair game, but the assets then become protected. So while the lawsuits target the operating company, the asset company stays safe. And that's how every business should be thought about. Real estate runs like that, restaurants run like that, and you should actually run your ABA like that as well. But I just want to digress for 1 minute because there's another trick, and it's nothing to do with the ABA business, but it's for you personally as an ABA owner or anything that you own. You should probably be protected. It's called the Wyoming Holding Company. The Wyoming Holding Company should be you. You should never go into business. You should have a Wyoming Holding Company that goes into every business that you ever go into. So if you open up an LLC, the owner of the LLC that you're opening up should not be you. It should be your Wyoming Holding Company. The Wyoming Holding Company is your personal bodyguard. And the reason is that, as I said, every state has different LLC rules and they have different levels of protection. Without getting into details, Wyoming will give you the strongest firewall between you and your LLC. It's the hardest in that state. It's very hard to get from an LLC to pierce the veil and get after a person's personal assets. And it also protects the LLC from any personal creditors you have. The second reason, well, I covered the first two right now. The third reason is privacy. Wyoming Holding Company can be anonymous. So if you don't want people to know, not all states can have anonymous. So if you open a LLC in Ohio, you have to list who you are, and people can look up and know what kind of assets you have. But if you want to be anonymous, so you have a Wyoming Holding Company, the Wyoming Holding Company will not list you, will not tell anybody who the owner of the Wyoming Holding Company is. And instead of you being the owner of your Ohio LLC, your Wyoming Holding Company is listed as a member of your Ohio LLC, and therefore you don't ever appear in the public record if you're careful. It's a little bit more complex than that. There are more steps you have to take, but that's the general idea, which is why, again, before we even get to LLC protection within the ABA industry, everybody who goes into business should know that a Wyoming Holding Company is something that they should probably consider before they do anything. So back to our ABA. We discussed the operating company and the asset company. In the ABA world, there's something called an MSO, which many of you probably know about, which is a management agreement with the operating company. So you have an MSO that does all the heavy lifting, all the back work, and the operating company, which is the one that provides the services. Now, the operating company is typically the one that's going to be sued, which is why you want to hide the rest of your business in the MSO. And we'll see during the course of all the risks that we see when it comes to ABAs, we will see that having an MSO saves you from a lot of the headaches. Okay, so the MSO is the business engine and the OPCO is the clinical care. So what does the MSO do? The MSO could manage the revenue cycle, the human resources infrastructure, the facility and technology management, and very importantly, the brand and marketing assets. And we're going to see how we stack it up because LLCs are like Lego pieces. And if you stack it up right, you can build a really strong structure. The operating company will take care of the professional licensing, the clinical staff employment, medical records management, payer contract management, and the treatment delivery oversight. So you see that the operating company is in very dangerous territory. We don't want to have any assets in the operating company. The operating company could bill, and money comes in and goes out. Nothing should stay in the operating company because that's a target for lawsuits. The MSO is one step removed and therefore more protected. Okay, so now this is a question that we get asked often. What happens if you're scaling for multi-state? A lot of people think that, okay, I have an LLC in, pick a state, New Jersey. Now that's my business. My business is the LLC in New Jersey, my ABA Therapy LLC in New Jersey. and now I want to open up in Pennsylvania. So what do? There's two ways to do it. Either I can form a new company in Pennsylvania, or you can actually register your New Jersey entity to do business in Pennsylvania. Because what you need to understand about LLCs is LLC is permission from the government to do business in that state. It's not a federal law, it's a state law. So that means each state has its own LLC. If you want to do business in New York, you need a New York LLC. If you want to do business in New Jersey, you have to get permission from New Jersey and have a New Jersey LLC. But let's say you start a business in one state and now your operations expand and you're going to other states. You have two choices. You can either fully start a new business in a new state, or you can turn to the second state and ask the state government, please qualify my New Jersey business in your state. Let me do business in New Jersey and you are registered with the state. That works. The problem is that it doesn't give you protection. That means that you're operating under one LLC. And if you are sued in Pennsylvania, they will come after your entire LLC. And with the principles we learned, you want to segregate your risk, especially when it comes to ABAs, because you have a lot of risk and each risk is in the state that you're in. So you don't want any Massachusetts or Pennsylvania or Ohio risk to ruin your New Jersey or New York business. So you should typically start a separate entity in each state, and therefore it becomes a little bit more complicated. Now, the complication of doing that is it has nothing to do with the LLCs. The LLC is the cost, and the filing is the same whether you're foreign qualified or whether you have two separate LLCs that aren't related. What's complicated about is that it's run as a separate business, and now you have another tax return, and they're not related. Now, the good part about that, and we'll talk about this more later when we talk about exit strategies, is that if you are running different state businesses, you probably shouldn't put them all in one basket. You should be able to see how each state is doing, and each state should have its own set of books. That will show you which states are operating well, which not, and will certainly help you zero in on problems and help you improve your business in that state, or when to give it up. Another reason why you probably want to separate the entities and not foreign qualify in different states is because if somebody wants to buy, they're not buying your whole portfolio, let's say. They may buy your whole portfolio if you do well. They may want to cherry pick a certain state, and because that fits in with what they need, and you may want to sell the state separately. Now, if you have a separate set of books, that becomes easier. If everything's run differently, if it's intertwined and embedded in your entire operation, it becomes a mess to unravel, it becomes a mess to sell, and it would be a lot harder to have a successful exit from that state if you have only one set of books. So for the multi-state operation, we're going to add one level over here. First, you'll have your separate state LLCs. Now, when it comes to the MSO, what's nice is you don't need a separate MSO in every state. We will talk about that a little later, but what you could have one MSO structure that oversees your entire operation. Remember, the services that the MSO are giving don't vary from state to state. So that could be your central headquarters that gives all the services that your MSO gives. And then where the risk lies, which is in the operating companies, the separate state LLCs, there you'll have different LLCs. Now, if you want to do one layer on top of that, you can have a holding company, which not only provides centralized control, but it will hold all the intellectual property. It can hold real estate if you have real estate in different states, and it will hold all the real valuable stuff, which means that it's two steps separated from a liability. Okay, I think we said enough about the LLCs, and like I said, we'll get back to the LLCs as we go through all the different risks and show how it comes into play. The next part of risk is accounts receivable. Accounts receivable is your biggest revenue. It is your revenue. That's what you get in the ABA business, and it's a little bit complicated in the ABA therapy business, as we all know. So let's start with the beginning. Your revenue comes from mostly Medicaid and private insurance, which is good because that means people are using your services, especially since it's mandated by most private insurances today, which means that people can afford it because they are covered by, they don't have to pay their own bills. The bad part about that is that the government's giving you the money, and therefore it's not as simple. And there's all kinds of regulations and oversight, and we'll talk about clawbacks. So this is both the risk and the success of ABAs. So how do you get money from Medicaid and from insurers? You don't just bill them when you have a client. You have to actually be set up with Medicaid, and you have to be set up with insurers, and it's almost the same enrollment. The basics of it are that you need NPI. You have to have a national provider identifier, which is a unique 10-digit number, which is issued by the CMS. Now, there's two types of NPIs. One is NPI 1. That's for an individual provider. So in order to get money, we need to see, the state needs to see, who the BCBA is on the case, who's providing the therapy. The second thing it needs is the organizational provider. It needs to know the company that's providing the services. So that would be your LLC. So what happens is the LLC is the MP2. They enroll, but they must list the NPI 1, the individual provider, on when they set up their billing with Medicaid and insurers. So the first thing you do is you enroll, and enrollment doesn't go so fast. It takes a little bit of time, which we'll see becomes a very big risk for this whole process. So each BCBA must be enrolled using their individual MPI, and you need the entity enrollment. And just remember that Medicaid, if you don't do this right, if you don't set this up right, let's say your NPI 1 leaves the company and you try to bill them without an NPI 1, or you have the wrong NPI 1, you may get paid, but it may come back to haunt you. And Medicaid can claw back for 3 to 5 years, and that money is long gone because, like we said, it's revenue. You're not keeping it in the company, and somebody's going to have to come up with the bill. So let's look a little bit about insurance. Insurance companies need you, they have a special database called the CAQH, which is the Council for Affordable Quality Healthcare. You have to put all your information to the CAQH and check on which insurer you want to enroll with. And then the process takes about 6 months before you are actually enrolled with them. Meaning that if anything changes, it could be another 6 months that you cannot bill the insurers. Okay, so first thing you do is you put it in the CAQH. The insurers get the access to it. They can pull the information, and then they come back and approve you. Now remember, with the CAQH, there's ongoing maintenance, which means that you have to currently update your licenses of all your BCBAs and all the current information. And if you don't, then again, you won't be in compliance, and the insurers can technically ask you for the money back for anything you billed with any lapses. So it's very important for the MPI 1 and MPI 2 to work together. You have your operating company, which is going to actually bill the insurance company. And then you have your BCBA, which every bill that you give to the insurer has a BCBA on it. If you have only one BCBA, that means that as soon as that BCBA leaves, you can no longer bill until you enroll another BCBA, which can take, again, it can take up to 6 months. And you don't want to be without the ability to bill for 6 months. So you certainly want to keep a few BCBAs on staff that are all enrolled and in the CAQH under your company listing. Now, there's some people out there may be BCBAs thinking, okay, I'd love to do this myself. I'd love to bill clients directly. So there's a couple of problems with that. You don't technically need a company to bill with, but Medicaid and insurers are cracking down on that, and they don't like to pay to MPI 1s without an MPI 2. But the bigger problem is that if you're going to bill directly, all the problems come back to you. That means that you don't have an LLC, which means that if there's any clawback, even if the money's long gone, you're going to have to pay, and it's going to cost you your house and your car and everything else. So what you want to do, even if you're a BCBA and you want to go on your own, you want to start an LLC, you want to get your NPI, and then you want to list yourself as the NPI 1, and then you could start doing business. And this way you can actually scale, because with an MPI-1, you can't scale. It's just you alone, and there's no way to grow. Okay. So what's the problem with the clawback? The payers review the entity type. Every now and then you have to re-credential, and then it may trigger an audit, and they may look at all the information from all the past years and see that you weren't in compliance during all those years. And then they could void your contract, they can demand repayment, and they could deny coverage going forward. So it's very important to be set up properly and not have any lapses, because if you're going to have a lapse, you're going to try to do something to bridge that gap, and it may not be worth it for you. So keep everything in compliance in order that you don't have that audit, which will then lead to a clawback. Okay, so the look back period you'll see over here, Medicaid can look back 3 to 5 years. Commercial insurers typically look back 1 to 3 years under the contract term that you sign with them. So how does the LLC protection strategy work? You have your entity liability shield, which means that the clawback will only hit the OPCO. It won't hit the MSO. As we said, if you have the MSO plus OPCO strategy, your MSO will be protected. If you're in multiple states, a clawback in one state won't destroy your whole business. Remember, if you have one LLC that's foreign registered in all the states, that means all the money in all your states become available, exposed to any clawback in a single state. And when you're running a business that big, you don't want to take that risk. And most importantly, not most importantly, but also your personal assets will still be protected from a clawback. Now, any LLC protection, as we said, will only work if there's a suit against your LLC. But anytime there's fraud involved, and if they determine that you aren't in compliance in the CAQH database, and they consider it intentional and there was fraud, so your LLC will no longer protect you anymore, because that is not protected by an LLC. Let's talk about employment risks. Now, we know that employment is very hard in the ABA industry, and it's probably the hardest problem to scale because of the lack of qualified employment. So we have the issue of hiring quick employment and the issue of having a W-2, which is an employee of the company, versus a 1099, which is an outside contractor. So the reason why you would want to hire an outside contractor is because a W-2 comes with a lot of baggage. You have tax responsibilities, you have withholding tax, you have Social Security and Medicare, you have payroll taxes, you also have the benefits. Employees qualify for health insurance, paid time off, retirement plans. The employer actually controls the company controls the employer in this case, and he provides you're providing the training and you're maintaining the supervision protocols. So all these things show that this is a real employee, and these are the responsibilities of having an employee. But on the other hand, if they're W-2 employees, then you have lower compliance risk, because they won't do an audit on you. If they see too many 1099s, they'll do an audit. And for it to be a 1099, what's nice about it is that their tax burden is on them. There's no benefits. They have operational independence, and it's very attractive to you, but it becomes very risky when it comes audit time. The reality of ABAs is that 1099s rarely work. The reason is because you have direct supervision for ABA therapists, and direct supervision means automatically it's not an outside contractor. They're also using the company resources that you have. They're also scheduled. They don't have their own schedules. The schedules work on the company schedule usually. And often they represent themselves as company employees. So all these things are red flags when it comes to 1099 workers. If they do an audit and you claim that these are 1099 workers, and they see that their schedule is being given to them and their supervision and any of these other issues, then you will have a problem. So what happens if you misclassify an employee? First of all, there's IRS, state, and tax penalties because you were supposed to collect payroll taxes. There's employment law claims because they should have had overtime. They should have had benefits, and all these you didn't give them, and you could be sued for that. And there's also the healthcare payer audits, which means that they may demand a clawback because if you claim that it was a 1099 and was really should have been W-2, so the insurer will say, we don't want to pay for those hours. And therefore, you'll have to give all that money back. The problem is that when it comes to state and tax penalties and employee law claims, this, even if you have an LLC, becomes personal liability. So by playing around with the W-2 versus the 1099, not only do you jeopardize your company, but you have personal risk involved as well. So the best practice is to default to a W-2 employee. You should only have 1099 if they're actually really independent. And if they are, you need to document exactly why and how their day works. So you can show the classification documentation if there's an audit. And the main thing you have to do is really understand that that's part of the cost of doing business and build the employment costs into your business model. Now, the red flag checklist we don't have to look at. It's we discussed all these things. So let's move on. Okay, our next problem is regulatory challenges. And this is also a very big issue that not everybody understands completely. There's something called corporate practice of medicine doctrine. Now, what that means is that states, or this doctrine says that businessmen should not be running professional companies. Because if you are a therapy company, or you're a medical practice, or you're a psychotherapist, we know that if you're a psychotherapist, you understand what's at stake for the client. If you're a businessman, you understand dollars and cents, and you will be squeezing. And there's often a conflict of interest between a businessman and a professional when it comes to providing professional services. So what the CPOM says is that in order to own a professional services company, you must be a registered professional in that field. So now the question becomes, where do BCBAs fall and where does ABA therapy fall into this picture? Is this a professional service or not? Okay, so in New York, we had, let's jump over here. Until 2014, it was certified, BCBAs were certified by the Department of Health, which didn't put in any danger of being called a professional service. But in 2014, the Department of Education made it a licensed profession. So now BCBAs become a licensed profession. Now it wasn't really enforced in until 2022. From 2022 onward, every BCBA is a licensed professional, which means that you need this for the insurance companies will insist that you have a licensed professional giving the treatment. Now the question is, what about CPOM? In New York, can a businessman who is not a licensed professional own an ABA therapy company? And the answer is that it's a gray area. The reason is because while there is licensing requirements for a BCBA in New York, it's not yet listed on the list of professional services. So since it's not listed on professional services, there's a question if you need to have a PLLC in order to run ABA therapy business. So there's two ways to look at it. One day, New York may wake up and say, okay, we're now going to list ABA therapy as a professional service. If they do that, then great. So they now added it to the list of professional services, and everybody will have to be a PLLC. And we'll show you what you have to do in order to become a PLLC. The problem is that they may not do that. They may never list it as a professional service, and they may one day decide that, no, it doesn't have to be listed because it's already listed. It's been listed for the past 50 years as a psychotherapy or a psychology. And any psychology or psychotherapy practice needs to be a PLLC, which means that retroactively, certainly to 2022, and maybe before that, you should have been a PLLC and had no right to run your company as an LLC. And then what happens as soon as that happens? Of course, that's when the insurance company and Medicaid come running, screaming that all the money we paid you for the past depends how aggressive they want to be, past 3 years, past 10 years, all was given fraudulently or at worst or at best mistakenly, and we need the money back. So anybody running today in New York, ABA therapy without a PLLC is in serious jeopardy, because technically it's going to be a PLLC. The question is how that comes down, but it's going to happen. Now, the reason why people still run as LLCs is because, very simple reason, Medicaid and insurers are still paying, and nobody wants to rock the boat, and they think as long as they're getting paid, everything is okay. And the reason why they're doing that is because they're a little slow. They're not very fast-moving businesses. And just understand that as you continue billing, you're just adding to that pile of potential clawbacks. You may be making revenue now, and you may not want to disrupt your business, but just understand, I would not spend that money too quickly because it may not stay with you forever. So what happens beyond New York? It depends on the state. So Illinois is very strict. California and Massachusetts are very strict. Texas and Florida are much more flexible. We also have here more states where we broke it down into 4 categories with a strict enforcement. Then there's the business-friendly states. Then there's the watch list states, which are moving towards strict enforcement. And then there's the middle ground states, which are just wandering around, not saying anything, and hard to know what's going on. But in general, it's certainly worthwhile today because of the issues, and because if you're going to other states, you want to run as an MSO model, it's easier to let the operating company be a PLLC, have it run by a BCBA, a licensed BCBA, and you can run your business model like that. If you're not a BCBA, you can still have your MSO. The MSO does not have to be run by, does not have to be a PLLC. You have your MSO, you have your contracts in place. The BCBAs run the LLCs as a PLLC or whatever the state requires. And this way you stay out of any danger zone. Now, let's say you're in New York and you decide, oh, wow, maybe I should convert from an LLC to a PLLC. Unfortunately, there's no shortcut. It's as if you're forming a new company. You need to do the whole process. You need to register your MP2, because now your MP2 is not, you can't turn an LLC to a PLLC with the same NP2. You need to register your PLLC as an NP2, and then you need to credential all your NP1s together with that. So again, you're talking about 4 to 6 months in order to be up to date. Now, the problem with this model is, yes, okay, so you run your MSO, you own your MSO, and you let your BCBAs, you get a BCBA to run your operating companies, and you have agreements with them. But now you're dependent on a BCBA. The BCBA, once they walk away, now you still have your MPI2 because the LLC is still there. The question is, what happens with the LLC? Because the owner of the LLC is the BCBA. So if you're not careful, they can do whatever they want. They could change the rules of that BCBA and you lose everything. The BCBA can also walk away because they're probably the NPI1 as well for that company. So the MSO is not billing insurers and healthcare and Medicaid. It's the operating company. And the operating company is totally in the hands of the BCBA. So how do you protect yourself? So one way you could do it is you could have multiple BCBAs in the ownership structure. You should have a very comprehensive management agreement. There's an agreement called the MSA that's between the MSO and the operating company. And you have to have a very strict agreement, which we'll get into on the next slide. And you have to have backup clinical leadership pipeline, which means if the BCBA walks away, despite the contract that you have, then you have to have other people ready to step in place. You want to have other NPI1s already enrolled that they can just take over the billing. So you would make an agreement where you would keep the PLLC if they walk away. So the NPI2 would stay the same. The NPI1, you can just switch over to a different NPI1 because they're already enrolled with you, and then things continue smoothly. So let's look at some of the 7 critical protection checklist. You want to have a rock-solid management agreement, which means exclusive service provision, a clear fee structure, and MSO control over all non-clinical operations. So you want to leave that BCA in the operating agreement. You always want to do it for protection, but especially in this case, you want to leave them with a bare bones that can't even function on its own and is tied to the MSO in order to exist. You also want a long-term BCBA commitment. You want to have multi-year agreements. That could be 10, 15, 20 years with renewal provisions. And you want to have golden handcuffs incentives, which means if the BCBA walks away, then they leave a lot on the table, which means you can have an agreement where they forfeit any revenue from the PLLC. They can be bought out for a very cheap price. There's all kinds of creative ways that your lawyer, I'm sure, can structure this agreement in order to make sure that your BCBA doesn't really want to walk away. You also want to have succession clauses. You want to have the payer contract protections, which means that as much as possible, the MSO controls the billing infrastructure. Now, this becomes a little tricky because if the MSO exerts too much control over the PLLC, then the state can decide that the MSO is really controlling the PLLC. And if that's the case, then it won't be in compliance with CPOM. And again, you'll have all the problems with clawbacks. It will sort of be like piercing the corporate veil. It will be piercing the operating company veil, and your PLLC could be disqualified. You want to have comprehensive non-compete agreements with your BCBAs. Now, those are very hard to sign today, but I guess you want to do as much as you could within your legal rights. And of course, you want to have key asset control over technology, trademarks, websites, phone numbers, client list. Everything should belong to the MSO. And like we said, you should have backup clinical leadership that's willing to step in its place. Let's talk about the exit risks. You want to prepare your ABA company for a sale or a transition. Nobody lives forever, and nobody wants to work forever usually. So the idea is to make your company attractive, and you want to keep it in a way that when it comes time to sell it, it becomes very easy to sell and very attractive to sell. So you want to have something that readies you for an exit. Now, there are a lot of companies that want to sell, but then they go to the market and they realize it will take them another year to prepare the company for sale. You want to prepare your company or operate your company from day one that you can sell at a moment's notice, especially in the ABA business where there's a lot of mergers, there's a lot of people grabbing companies, and you are, especially if you're small, you want to be ready to be swallowed up and give up your company on a moment's notice if it makes sense for you, if the right deal comes along. And you don't want to go through a whole due diligence. You don't want to spend a lot of time negotiating a deal only for a deal to unravel at the last minute because you didn't operate it in a way that made it prepared for sale. So in order to do that, again, the first thing you should worry about is entity choice scrutiny. You should make sure that it's structured properly. That can make it easy to sell, which means separate companies, clear, transparent books, clear, transparent operations, all the regulations and everything and the licenses and the enrollment set up each state individually without any confusion. You want a clean MSO model. If you have a messy MSO model, then you probably won't be bought because your operating companies are not so secure and they become risky. So why would somebody buy a portfolio of companies that can fall apart as soon as new management comes in? You want to make sure that you don't have restructuring costs before any sale, and you want to make sure that it's limited exposure so everybody knows that they're not buying something that's going to explode as soon as they buy it. And if there is exposure, it will come from one piece here, one piece there, and not the whole thing at once. Nobody wants to buy a ship where the whole ship will sink. So here are the financial red flags. First of all, your accounts receivable have issues. If you see that there were denials, uncollected claims, clawback risks, you want your account receivables to be flowing perfectly. You don't want any issues back and forth with Medicaid or insurance. You want to do everything right so people can see that this company knows how to collect. You want to make sure that your payroll is classified the right way. You don't want any employee misclassifications. You don't want any documentation gaps. All the operating agreements, all the agreements, everything should be set up correctly, and you want to make sure that there are no other hidden liabilities. When it comes to the regulatory compliance diligence, you want to make sure the credentialing is very good. MPI structure is good. You want to make sure there's no problems with HIPAA, which is the compliance with the security and the privacy. And you want to make sure that you're not buying. I don't think any investor today or a big ABA company is going to buy a New York LLC today. So you want to make sure that even in all the states, I think the strong companies will want to insist that their PLLCs or whatever it is, professional CPOM requirements are followed in all states. So the seller should be protected. You want to protect yourself. You want to make sure that you have contractual protections. You have economic control over all your entities. You have asset separation, which means that all the risky parts of your business are separated out. And of course, you should get expert guidance anytime you're thinking about selling. If you're planning ahead for value, just remember you should be planning at least 3 to 5 years before selling and run it properly from then on. You can't always go backwards, but you want to show a solid 3 to 5 years operational excellence. Oops. Okay. Wow, this is bad luck. The slideshow is over. I did want to show you one more slide about what we actually do at NewCo. So I'm going to, let's see what we're going to do here. What happened to our slide? Okay, our slide disappeared. So I will tell you, oh, let's see. No, our slide is not showing up. Funny thing. Okay, at NewCo, I'll just have to tell you this by heart. We are an LLC company. We help you form and help keep your LLCs in compliance. We do all entities, nonprofits, PLLCs, corporations, LLCs, whatever it is that you need. We do it in all 50 states. And we keep your LLCs in compliance from year to year, which is not a simple process. It is simple, but very few people do it correctly. We are registered agents in all states, which means when you expand and you need registered agent for your out-of-town LLCs, we're there for you wherever you need us to be. We have a management portal. So even if you have 100 LLCs today and don't want to use our services, we give a free management portal, which is a game changer. Anybody who's seen the portal is blown away. It will change your compliance and save, I don't know how many hours or days from your team dealing with the LLCs. And we also do payroll and tax registrations in every state. So that will help you as well from that front. If you want to get in touch with me, these are my contact details. You can reach out anytime. You can call me after it's over. You can set up a Zoom. You can email me. Happy to answer all your questions at any time. Feel free, whether you're a client or not. I am here for you. If you like a recording and if you'd like this presentation, just send me an email and I'll be happy to send it right over. Thank you all for participating today. We appreciate your attendance, and if it's anything we can do to help you, let me know. Thank you.